There is one form that can override your will, override your living trust, and in some cases, even override state law. Before I tell you what the form is, take a guess in the comments. What form do you think could actually beat your will, beat your trust, send money somewhere you never even intended? Is it a deed, trust amendment, power of attorney? Is it some sort of crazy bank form? Put your guess in the comments right now. And if you've seen this happen in your own family, tell that story too, because this is one of those mistakes people do not believe until they see it happen. And unfortunately, I've seen it happen. The form I'm talking about is a beneficiary designation. Beneficiary designation. It sounds harmless. It sounds like one of those little forms you fill out when you open an account and never think of again. But that little form may control your 401k, your IRA, your life insurance, your annuity, your HSA, your bank account, your brokerage account, and sometimes even a 529 plan. And if that form says one thing, but your will or trust says something different, even if state law says something different, the financial institution is usually going to follow the form. Not your will, not your trust, not your hand note, written note for sure. They're going to follow the form, not what your family swears you wanted. Like, hey, there was a divorce. Why would dad ever have left his ex to, something to his ex? The form wins. And this is where people get blindsided. They say, hey, wait a minute. Dad had a trust, or mom updated her will, or the attorney drafted everything and said it was all handled. All of that might be true, but some assets don't pass through your will. Some assets don't pass through your trust. They pass by contract. And the contract is that beneficiary designation form. And this is why estate planning is not just about having documents. It's about making sure the assets actually move the way the documents say they should move. Because if the will says one thing, trust says another, beneficiary form says something else, your family may be in for an ugly surprise. Let me show you how bad this can get. So I'm going to share with you a couple cases. One of it was, there was a guy named Warren Hillman, and he worked for the federal government. And he had life insurance through what's called the Federal Employees Group Life Insurance Program, which is, I think they call it FEGLI. While he was married to his first wife, Judy, he named her as a beneficiary, which is normal. Married people name their spouse all the time. In fact, that's what I would recommend you do. But then life changed. Warren and Judy divorced. Later, Warren remarried. His new wife was Jacqueline. Now, here's where most people assume common sense would take over. Well, he's divorced from his first wife. He'd remarried. He lived in a state, Virginia, where they even had a state law designated to deal with that situation. The state law basically said, if you divorce, your ex-wife should not automatically keep anything that she was on it for a benefit or he was on it for a benefit just because the old beneficiary form was never changed. In other words, they'll go back in and rewrite it. It actually creates a cause of action. In this case, it created a cause of action for Jacqueline to sue Judy for the proceeds of the life insurance trust because Judy was left on as the beneficiary. So ex-wife left on as a beneficiary, Warren passes away, new wife has a cause of action against the ex-wife saying, hey, you should not have received those money. And it sounds reasonable. That sounds like a law stepping in to fix what's a paperwork mistake. I just forgot to do it. But that's not what happened. Warren died. The life insurance policy named his ex-wife, Judy, as the beneficiary. The federal insurance program paid Judy. The widow sued. Jacqueline, his existing wife, when he passed, sued the ex-wife. And you can understand why, because she was the surviving spouse. Virginia law says, hey, you get this cause of action because we know there's no way Warren would have said, hey, I want my ex-wife to get my life insurance. But the case went all the way to the United States Supreme Court, and the court said federal law controlled. The FEGLI statute gave priority to who? The named beneficiary. and state law could not redirect the money after the fact. So the ex-wife kept the proceeds. That is the key. This is not just a beneficiary form versus family fairness. This was beneficiary form plus federal law versus state law and the beneficiary designation form 1. And when people say, my state probably protects me, that's why I get nervous. Maybe it does, maybe it doesn't. And if federal law governs the account, state law will not save the family. So let's talk about another case. Like Hillman, well, that involved federal life insurance. But the same problem can show up with retirement plans, which is where I'll bring up another case called Kennedy. William Kennedy worked for DuPont for years, and he had an employer retirement plan. When he was married, he named his wife as the beneficiary. Again, totally normal. Then they divorced, and as part of that divorce, his former wife waived her rights to the retirement plan. Understand this. The lawyers thought of this and said, so when they're doing the paperwork, you waive all rights to Kennedy's retirement plan. Ex-wife, you go your way, we go our way, whatever agreements they had, that was it. And most people would say, yeah, that problem's solved. She waived her rights to it. The divorce paperwork literally said, ex-wife, hey, you keep the retirement plan, I waive all rights to it. But Kennedy never changed the beneficiary designation on the retirement plan. When he died, the plan still had the ex-wife. And his estate said, wait a minute, she waived those rights during a divorce. But the plan administrator for the retirement plan followed the plan documents and paid the ex-wife because she was still the named beneficiary. And again, the case went all the way to the United States Supreme Court, and the court said, what the plan administrator did is what is required under federal law. ERISA requires it. Follow the plan documents. In plain English, the retirement plan paperwork controlled. The beneficiary designation form controlled. Not any assumptions, not the family expectation, not the divorce paperwork. At least as far as the plan administrator's duty, they had to follow this. Hey, the state, and you have a divorce, congratulations, that's all you. But I have to follow what is required under federal law, under ERISA, and I have to follow the plan documents, the beneficiary designation form. So now you have two Supreme Court cases giving you the same practical warning. In Hillman, state law tried to redirect life insurance away from the ex-wife, but federal law and the beneficiary designation controlled. In Kennedy, divorce paperwork said one thing, but the employer retirement plan documents said another, and the plan administrator followed the beneficiary designation. Different facts, same warning. Your life can change, your marriage can change, your family can change, your will can change, your trust can change. But if the beneficiary form does not change, the money may still go to the person on that form. And that is why this is so dangerous. People think estate planning means I signed a will or I created a living trust. And look, those documents absolutely matter. I'm a huge believer in living trusts. They can avoid probate. They can provide privacy. They can create control. They can keep you out of court. That's what you really want. They can help your family avoid a big mess. But a living trust does not automatically control everything you own. It's not just about ex-wives and different laws. It's about contracts, and many are not affected by your will or living trust. You might say, well, what about some examples? All right, your IRA may pass by a beneficiary designation. There's no living trust needed or anything like that. Your 401k may pass by beneficiary designation. Your life insurance may pass by beneficiary designation. Your annuity may pass by beneficiary designation. Your HSA, health savings account, may pass by beneficiary designation. Your bank account, you may have done a payable on death form, or you have joint tenants on it. Your brokerage account, same thing, transfer on death form, maybe you co-own it. Real estate may have a payable on death or joint tenancy as well. Your 529 plan may have a successor owner designation. And if those forms conflict with your will or trust, your family may find out the hard way that the form wins. This ties directly into something I've talked about before. There are assets you usually do not put directly in your living trust. Retirement accounts for a perfect example. You generally do not retitle your IRA or 401k into your living trust while you're alive because this is going to create a tax mess. It destroys that plan. You do not make the trust the owner of the retirement account during your lifetime. Instead, you coordinate the retirement account with your estate plan through the beneficiary designation. That is a big difference. Ownership is one thing, beneficiary designations are another. Ownership asks, who owns this asset while I am alive? While Toby's alive, he has an IRA. A beneficiary designation says, what happens when Toby dies? And if you understand that distinction, estate planning becomes much clearer. The mistake is thinking that a trust automatically fixes everything or a will fixes everything. They don't. The trust only controls assets titled in the trust or assets that name the trust as beneficiary. If your IRA names your brother, your trust does not magically go pull that back into your estate. If your life insurance names your ex-spouse, the trust does not automatically redirect it. If your brokerage account has a transfer on death designation, naming one child, your trust may not divide that equally among your children. The form controls the asset. So let's walk through the accounts you need to check. Number one, retirement accounts. These are your IRAs, your 401ks, your 403bs, your SEP IRAs, DB plans, cash balance plans, all your retirement plans. Do not assume that your will is going to control them. Do not assume that your trust controls them. You have to look at the beneficiary designation form. If you're married, your spouse will often be a primary beneficiary because the spouse gets special tax treatment. A surviving spouse may be able to roll the account into their own IRA and keep the tax benefits going, for example. And that is really, really powerful. It's also tricky because if you divorce, it doesn't automatically update. You have to go back and change this form. And this can be messy. And if you're like me, well, after my spouse, I'm going to add my living trust as a contingent beneficiary. And that's because if my spouse passes before me, I want to have my estate plan and handle that. And you might say, why? Because if your children inherit directly, they may get the money outright with no guardrails, no protection from creditors, no protection from divorce, no protection from lawsuits, no protection from bad decisions. Under current law, many non-spouse beneficiaries have empty inherited accounts. I mean, they have to empty the retirement accounts that they do inherit in a very short period of time. Usually within 10 years, they have to take it all out, and there's a tax implication. Or if it's HSA, it's immediately. Or like, let's say I'm leaving a large traditional IRA directly to a child. This can create both control problems and tax problems. And this is not something you guess at. This is something that you coordinate with an estate plan. So that's why I put my living trust as my contingent beneficiaries on a lot of these things. And by the way, I did a video on this recently. I'll put a link, 7 assets that you don't put into a living trust. That will help too. Let's go over number 2, because we did retirement plans. Number 2 is life insurance, because life insurance is one of the biggest places that things go wrong. Most life insurance already avoids probate because it passes by that magic beneficiary designation. So your will may have nothing to say about it, your trust may have nothing to say about it, unless the trust is named as a beneficiary. This means the life insurance company is going to pay whoever is listed on the policy. If it says a living trust, then that's where it's going to go, and then the living trust is going to control. I actually like that, but quite often we have the spouse listed as the primary beneficiary. And what they don't care about, they follow this form, not what you meant, not looking at who you're married to when you died, who took care of you. They only care about what's on the form, who's on the form. And that's why the Hillman case matters. The ex-wife was still on the form. the ex-wife got the money. And this would have happened too on a number of different items. Like number 3, let's go over this, annuities. And they often have beneficiary designations too. And like retirement accounts, there could be tax consequences depending on who inherits. And sometimes a spouse can continue the annuity. Sometimes non-spouse beneficiaries have different rules. Sometimes naming a trust will make sense to make it a contingent beneficiary. Sometimes it might not. But again, the answer is not, hey, look, I did a trust so I don't have to worry about it, I'm done. The answer is, what does this form in the annuity say? Number 4, HSAs, health savings accounts, are really easy to overlook because an HSA is tied to an individual. Like if it's me, it's me. And if my spouse inherits it, they might be able to keep it as an HSA. And that's usually the best result. But if a non-spouse inherits the HSA, it's usually no longer an HSA and the account may become entirely taxable. Boosh, tax. So again, I'm not just going to own an HSA in the trust. I need it to be me, then my spouse, then maybe make the trust the contingent beneficiary. What you need to do is you need to look at the beneficiary form and coordinate it with the estate plan. And if you get a divorce, you're going to have to go back and look at these. Number 5, let's talk about bank accounts, because a lot of banks use payable on death designations or PODs, and they don't necessarily tell you. You do it when you set up the account and you don't really think about it. A POD designation tells the bank who gets the money when you die, and it can avoid probate, which can be good, but it can also completely override whatever plan you put in place. I've done whole videos on this thing. Let's say your trust says everything goes equally to your 3 kids, but your bank account has a POD designation naming only one child. Maybe that child lived nearby, maybe they helped you set up the account, maybe that child helped you pay the bills, maybe you thought you would, hey, I'm just gonna do the right thing, or they're gonna do the right thing, or hey, they know what I want and they're gonna do it. The bank does not care about your family understanding. The bank cares about one form, which is the beneficiary designation form or the POD. And that one child, under that circumstance, is going to receive the entire account. And now the other kids are angry, and that's how families end up in lawsuits. Same is true, number 6, brokerage accounts. Brokerage accounts can also have transfer on death or TODs. This is common at places like Schwab, Fidelity, Vanguard, most brokerage forms. And again, a transfer on death can be very useful. It can avoid probate. It can move assets quickly, but if the wrong person is listed, it creates a disaster. And brokerage accounts often grow. So that account, hey, I had $75,000 in it when I filled out a form, and I didn't think too much of it, but now it's $500,000 today. So the mistake gets bigger over time. Number 7, your 529 plans. A 529 plan usually has an account owner, a beneficiary, and often a successor owner. You generally do not retitle a 529 plan into a living trust during your lifetime. It makes no sense. But you do need to know who takes over when you pass. And that's usually handled by a successor owner designation. Again, it's just a form. Another place where your trust may not control anything unless it's properly designated as a successor or a contingent successor owner. So here's the big idea. Some assets should be owned by your trust. Some assets should not be owned by your trust. But almost every asset needs to be coordinated with your trust. This is the part people miss. Funding a living trust does not mean blindly just putting everything into the trust. Again, we've done whole videos on why you don't put certain things in a living trust. Funding a living trust means making sure every asset transfers the right way. And some of that, sometimes that's going to be by the title of it. Sometimes that's by a beneficiary designation. Sometimes that's payable on death. Sometimes that's using a transfer on death. Sometimes it's by a successor owner designation, 529 plans. Different tools, same goal. Hey, we want a clean transfer, less tax, less court, less conflict. More protection. I want to have control. Now, here's the biggest mistakes to avoid. Mistake number one is assuming your trust controls everything. It does not. Your trust is powerful, but it's not magic. It controls what it owns and what properly flows into it. Mistake number two is failing to update these things after divorce. I just went through two cases, Hillman and Kennedy. That was the problem. Do not assume that divorce fixes the beneficiary form. Like, I don't do that during that proceeding. Do not assume that your state law is going to save you. Do not assume that a financial institution is going to do the right thing. They're not there to interpret your life story. They're there to follow the paperwork. Mistake number three, don't name your minor children directly. Sounds loving. It can also create a mess. A minor cannot usually receive a large account outright. And now a court is going to get involved and they're going to appoint someone to manage the money. And that creates cost delay in court supervision. And when the child reaches legal age, they may get the money outright, whether they're ready for it or not. If you want money protected for children or grandchildren, that's where a properly drafted living trust is incredibly useful. But if you do this, POD, TOD, beneficiary does, and you go around the trust and you give it directly to those minor kids, you're asking for trouble. You're going to make their lives worse unintentionally. Now, mistake number four, not having contingent beneficiaries. So a primary beneficiary is your first choice. A contingent beneficiary is a backup for if they predecease you or if they're not able to handle the funds or whatever it is you're leaving. If your primary beneficiary dies before you and there is no backup, then the account could end up in probate. It can mean delays, it can mean taxes, it can mean the wrong people get the money. Every major account should usually have a primary beneficiary and a contingent beneficiary. I like using the living trust as the contingent beneficiary for a bunch of reasons, not the least of which is because I do not have a crystal ball and I cannot predict the future. So I want to have something there to handle that for me in the event, because I can't see what the future is. So I don't know what's the situation, so I want to give somebody the ability to help my estate. Now, here is your action item. Do this week. Not someday, not when you get around to it. Do it this week. Ready? Start with an inventory. Make a list of every account you own. I'm talking about your checking accounts, your savings accounts, your brokerage accounts, your IRAs, your 401ks, your 403bs, your pensions, life insurance, annuities, HSA, 529 plan, real estate, your business interests, your vehicles, everything. And next to each asset, write down one question. How does this transfer when I die? Does it transfer by trust, by will, by beneficiary designation? Maybe there's a payable on death or a transfer on death. Is there joint ownership? Is there a successor owner? Or do you have no idea? It's okay. We want to just list it out. And if you do not know, that's not failure. That's the whole point of this exercise. You're finding the holes before your family finds out, ouch, there was a big hole there. They didn't know about it. Now it's just a big old mess. And the easiest way is to start with our emergency binder. It helps you list your accounts, your assets, your contacts, your instructions, your passwords, your advisors, your insurance, legal documents, and information your family would need if something happened to you. I'm telling you, this is half the battle, because most estate planning disasters do not happen because people had nothing. They happen because nobody knew what existed, where it was, who to call, or how it was supposed to transfer. So I'm going to make this easy. I'm going to give you the emergency binder. So just download it. It's free. I'll put the link in the show notes, and then start the inventory. And that binder rocks. This is the all hell's breaking loose. What does my family grab so they're not digging through everything? And don't worry, I mentioned the passwords. I put it on a separate sheet where it can be secured. Nobody's going to be able to get into your stuff with just the binder. They're going to need both those documents. But at least it'll tell them how to find who has that document or how to access it under certain circumstances. So we're going to do the inventory. We're going to look at every beneficiary designation. It's finite. Seems long, but you'll get there. Do not rely on your memory. I say, I think I did this. Log into the account or call the institution, ask for some sort of written confirmation. Who is the primary beneficiary? Who is the contingent beneficiary? Is the form complete? Is that person who's listed, are they still alive? Are they still the right person? Does it match what you want, like in your will or your trust? Does it match your actual plan? And if you get stuck, talk to a professional. This is what we do. We help people sort out tax, legal, estate planning, asset protection, so that everything works together. Because this is not just about having a will, it's not just about having a trust, it's about making sure the entire plan, the will, the trust, the account titles, the beneficiary forms, the tax rules, asset protection, the family dynamics, it all has to line up, it all has to work. So if you want help, schedule a strategy session with one of our professionals. Again, it's absolutely free. And we can help you look at what you have, identify the gaps, and figure out whether your assets are actually flowing the way you think they are. And before you go, drop a comment. Did you guess the form correctly? Be honest now. And have you ever seen something like a beneficiary designation form cause a family fight? Have you ever seen money go to the wrong person because an old form was never changed? Share it in the comments. People need to see this. Your story may be the warning that saves another family from making the same mistake. If you've not watched my video on the 7 assets you should not put in a living trust, watch it next. Because this video and that, they really go together. This video and that one really do work together. And a trust is powerful. But the power is not in throwing everything into it. The power is knowing what belongs in the trust, what should stay out of the trust, and how everything transfers when you're gone, because that's estate planning. It's not just documents, it's a plan. So remember this, your will matters, your trust matters. Even if you have a living trust, you're still going to have a will. It's going to be a pour-over will. But remember, that beneficiary form, this little guy right here, can override both of them. So check them before your family has to. Thanks, guys.